With that, we come to the third right, that is right to communicate the work to the public. This right, again, as was the case with right of distribution and reproduction, this is again available to all the classes of works, that is all literary, dramatic, musical, artistic works and sound recordings and films. Now, what exactly is communication to public? Section 2FF defines it. It says communication to the public means making any work or performance available for being seen or heard or otherwise enjoyed by the public directly or by any means of display or diffusion other than by issuing copies of it, whether simultaneously or at places or times chosen individually, regardless of whether any member of the public actually sees, hears or otherwise enjoys the work so made available. Now, the activities like broadcasting, webcasting, simulcasting, video on demand, etc., they all are covered within the broad framework of communication to the public. That means the owner of copyright alone has the right to broadcast it or authorize somebody to broadcast it, to webcast it, to simulcast it or to provide it in any other form. Similarly, exploitation in cinema hall or in a restaurant, that is also covered within communication to the public. Uploading, if for example, I buy a CD containing a film, is it possible for me to upload the film on YouTube legally? Well, that is not, because that uploading will become communication to the public. Now, if I upload it on my Facebook, which is with the settings of public, that means it is available to all the people whosoever are members of the Facebook service. Have I infringed the right of communication to the public? Yes. Even if nobody watches it on the internet, just the aspect of uploading it on the internet would amount to communication of the work to the public, because this is, the definition says that this is communication to the public is regardless of whether any member of the public actually sees, hears or otherwise enjoys the work so made available. So, it is the aspect of making the work available that would amount to communication of to the public, rather than the reception of the work by the public, actual reception by the public. Now, important aspects here are making the work available. Then another important aspect is public. If you make something available privately, something which is not public, then it does not amount to communication to the public. Now, the concept of public has not been defined in the statute in our Copyright Act, but we understand it, what public means. We have to use this expression public in contradistinction with the word private. So, making a work available within the private circle of close friends or family members may not amount to communication to the public. Another important aspect here is any means, because the definition is wide enough to include any means of display or diffusion of a work other than actual issuance of copies of the work to the public, because actual issuance of copies of the work to the public is already covered by the right of distribution. Then next right that is available in the bundle of economic rights within section 14 of the statute is the right of adaptation. Now, adaptation, what exactly is adaptation? Adaptation is a concept which has been defined in the Copyright Act 1957. It could be various aspects could form adaptation. One is if you change the form, if you convert a work into another work, for example, if you convert a literary work into a dramatic work or vice versa, that will amount to adaptation. The second is abridgment. If you abridge a work, that is also considered as adaptation. Then transcription of a work, for example, you transcribe musical work, that is covered within the definition of adaptation. Any sort of rearrangement of a work is adaptation, and any alteration is also an adaptation. So, if anybody except the owner of copyright in a work does any of these things, then it would be called an adaptation, and if he does so without permission, he would be infringing the exclusive right of adaptation which is available to the owner of a work. Now, this right of adaptation is available not for all the works, it is available only for literary, dramatic, musical and artistic works. It is not available in case of computer programs, films and sound recordings. Now, there was an interesting case regarding this right of adaptation. The name of the case is Macmillan and Company Limited versus K&J Cooper. In 1920s, it was decided by the Privy Council, which was at that time the highest court of appeal for all civil and criminal cases arising from India. Now, the facts of this case are something like this. Macmillan and Company had produced a book. The title of the book was Life of Alexander the Great. Now, how they had produced the book, we will come to it a bit later, but what was their case? They had filed a suit against the defendants K and J Cooper and Company, because K and J Cooper and Company, the defendants, had copied their book verbatim and also added a few notes of themselves. Now, the case was filed under the theory of copyright infringement. So, in such cases, the first question to be asked of the plaintiff by the court, in this case the Privy Council, was how establish whether your work is a copyright protected work or not, because if the work is not copyright protected, there is no question of its infringement. So, while explaining or demonstrating to the court that how their work is copyright protected, they had to demonstrate how the work was created. Now, how the plaintiff's book, The Life of Alexander the Great, was created. This book was drawn from a public resource. That means, some material which was out of copyright domain was available to be freely copied by anybody from the public domain. So, the plaintiffs had chosen such a work. Now, what they had done? They had reduced the corpus of the original work. That means, if the corpus of the original work was 40,000 words, they had chosen to copy 20,000 words. That means, they omitted half the work. So, how this work was reduced into half? It is very important to understand, because they chose certain paragraphs from the original work. Now, if there was, say for example, if there were 1000 paragraphs, they chose 500 paragraphs. Wherever they chose a particular paragraph, they chose it whole, and wherever they omitted a particular paragraph, they omitted it completely. So, that means, the plaintiff's work was a work of selection of half the paragraphs from the work which was publicly available to be copied by anybody, because it was in public domain. Now, this entire work of the plaintiff was verbatim copied by the defendants. Now, the plaintiffs alleged that this amounts to copyright infringement. Now, the plaintiff's work, in order to be entitled to copyright, has to be covered within the definition of adaptation, because if it is adaptation, then adaptation commands independent copyright like a new work. Now, all the plaintiff had to establish was their exercise of reducing the corpus of the work, reducing the size of the work, is covered within the concept of abridgment as is defined in the Copyright Act of that time. So, in order to find out whether this is abridgment or not in the copyright sense, the Privy Council depended upon a classic work on copyright, that is a book written by Coppinger and Scone James. Now, there it was explained that in order to be entitled to be called an abridgment, in order to be entitled to become an author of an abridgment, the entire sense of the work must be preserved in a lesser corpus of the work. That means, you should reduce the size of the work by maintaining the message, by keeping the message, entire message of the work. The language used should be substantially different. Any sort of mechanical omission, cutting of the work and preserving the rest of the work would not amount to abridgment of the work. But in case of the plaintiffs, this exactly was the case. They had only cut certain portions of the work and kept and preserved the others. So, the Privy Council held that this is not a case of abridgment at all. If it was not a case of abridgment, the defendant could not be said to have violated the copyright of the plaintiff. This was decided in this fashion, and we still follow the reasoning of this case. That means, independent effort, some sort of independent effort, skill and labor must be apparent in case somebody wants to become an author and owner of a new work. So, in this case, because the plaintiffs had only omitted certain portions and kept certain other portions of the work, they could not be held to have become authors of copyright and thereby owners of copyright in the work. Next right that is important is the right of translation. It is available for all literary, dramatic and musical works. It is not available in case of other works. Now, translation as opposed to adaptation has not been defined in the statute. So, for that we can refer to Shorter Oxford Dictionary, for its definition. This dictionary defines translation as the action or process of turning from one language into another. Also, the product of this, a version in a different language, the expression or rendering of something in another medium or form, transformation, alteration or change. This is how the Shorter Oxford Dictionary defines adaptation, it defines translation. Now, in a case, Apple Computers Incorporation versus Computer Edge, this is an Australian case which was decided in 1980s. It was held that conversion of a source code in a computer program, which is often written in hand, into an object code or machine readable language is tantamount to translation. So, translation is a separate right, that means it has a separate copyright. That means, if for example, A has written a novel, can we translate novel in English language, can we translate it in Hindi language without the permission of A? The answer is no, because translation is an exclusive right that has been granted by law to the owner of copyright in a work. Now, if A authorizes B to translate the work, then who shall be the owner of the resultant work? Will the resultant translated work be an original work commanding independent copyright protection? Yes, that is the case of copyright. That is what is provided under section 14 of the Copyright Act of 1957. So, if B translates it in Hindi, then the copyright would belong to whom? Copyright in the translated work, it will belong to B, unless there is a contract to the contrary between A and B, whereby A could stipulate that the owner of the translated work would be A only.